Good evening, everyone. We are delighted to be presenting this webinar live from the Cairo Regional Center for International Commercial Arbitration. And this is a Dispute Resolution Board Foundation event hosted by CRCICA on the use of dispute boards for opinion and dispute avoidance. And actually, this is a very unique topic because when you hear dispute boards or dispute adjudication boards, we're always thinking of decisions, binding decisions, and the debates are always, is this final and binding or is it just binding? This webinar is talking purely addressing the matter of opinion, not decisions, not final and binding, not binding, and so on and so forth. I am delighted and honored to be accompanied by the very distinguished Dr. Tariq Hamid in this presentation. Both Dr. Tariq and I are DRBF members and are presenting this presentation as such. Now, a few housekeeping rules. This webinar is not intended to be theoretical. It's intended to be interactive, and we will be counting on you, on your participation. You can participate through the chats where possible. And there will be parts in this webinar where we will ask you to participate through your own voice. So make sure that you you put your cameras on and your mics on when prompted to do so. Now this webinar is held, today is of course the 31st of August. It is very timely to be held in the CRCICA because for those of you who don't know, CRCICA have issued their dispute board rules that have come in force from the beginning of this month of this webinar. And therefore, it's only timely that we have this event in light of the CRCICA dispute board rules, which we will refer to at some points in this presentation as well. Now, to introduce Dr. Tariq, a man who actually needs no introduction, Dr. Tariq Hamid has over 30 years of experience in construction contracts, claims, and dispute resolution. His PhD is from Cairo University. His PhD, by the way, the research was definitely a very great research that actually benefited me in my PhD. And he has a diploma in international commercial arbitration, Cairo University, and the BSc, MSc in Cairo University, and he's managing director of DAR for engineering contracts. My name is Walid Al-Nimr, and I forgot to mention Dr. Tariq is a DRBF member, and I'm also DRBF member and representative of Egypt. I have 24 years of experience in construction contracts and claims. I have a PhD in construction law from University of Salford, LLM, and I'm also proud to be an AUC, American University in Cairo graduate. In terms of my bachelor's in construction engineering and in master's as well. I'm associated with the CIARB Egypt as well, the Chartered Institute of Arbitrators, and AAC International, which is the Association for the Advancement of Cost Engineering. And I've also taken assignments as an expert adjudicator and an arbitrator. I'm currently an adjunct assistant professor in the construction engineering department at the American University in Cairo. And I work in El Hill International, North Africa, as the contracts director. Now, before we start, we would like to take a poll. And please indicate your specialty within the construction industry. We would like to know if you're a contractor, if you're working for the employer as an engineer, project manager, or consultant, if you're an employer, or dispute board member, or others. Okay, so we're waiting for the results. Okay, so the results are out. 25% are the contractors, 31% the engineer, project manager, or consultant, 10% employer, 13% dispute board member. This is interesting. Others are 31%. So it's interesting because Dr. Tariq, because we have almost comparable results for contractors, engineer, project managers, and even others as well. Okay, so the second question. Yeah, first, before we go into the second question, we'd just like to give a brief introduction, a brief background as to the types of dispute boards. So we're familiar here in the MENA region and Africa and the North and the Middle East as well with dispute adjudication boards. So because we're all familiar with the FIDIC contract, and we know that the dispute adjudication boards provide, binding decisions, and we know that in the FIDIC 2017 contract, there's now what's called the Dispute Adjudication and Avoidance Board, DAAB. So, but these are not the only, this is not the only type of dispute boards. Actually, according to the ICC, the International Chamber of Commerce, we have a dispute adjudication board. Of course, this is what we just mentioned, but there's also the dispute review boards, which issues recommendation, non-binding recommendations. And then there's also the combined dispute boards, which is a combination of both. It can issue a binding decision and a recommendation. Now, the dispute boards as well, they have, there are different types of dispute boards according to the duration of their assignment. So if we have the project duration, we can have a dispute board that is present throughout the project duration. In that case, this dispute board is called a standing DAB. And we can have a dispute board that is just its task is just for a certain dispute. It just comes in, parachutes in the project to address a certain dispute, and then just that assignment is over, and that is called an ad hoc DAB. And of course, the avoidance role that we are stressing on this webinar is more associated with the standing DAB, because the standing DAB is there from the start. It visits the project periodically. It tries to see what the problems are, even if there are no disputes. It just goes and tries to get a feel of what the problems are and try to resolve them as soon as possible. So now we go to the second set of questions. So the first question is, have you experienced a dispute board procedure in your career? And by that, we mean any kind of dispute board procedure. Were you involved in any kind of dispute procedure at all? Yes or no? So we're waiting for the results. So the results are out, and 39% said yes, 61% said no. This is actually what we had expected. So now we can go to the second question. So from those who said yes, was the dispute board used for opinion or not? Because as I mentioned, dispute boards are commonly used for, of course, DABs are commonly used for decisions, but from your experience with dispute boards, did you ever utilize the dispute board for opinion? Yes or no? The results are out, and I think it's what I had expected, Dr. Tara. 58% said no, and 42% said yes. Frankly, Dr. Tara, and actually I thought that there would be less yes. I thought that there would be more.
I share with you this.
Yes. Actually, it would be interesting to get the views of those who said yes at some point in this presentation and their experiences with using the dispute boards for opinion. And I think there will be a chance for that in this webinar. Now we can go to the third question. So before this webinar, were you aware that one of the dispute board, now we're talking about dispute adjudication boards. So we're talking this question, dispute adjudication boards, key rules is to avoid disputes, not just render a decision. Were you aware of this, this dispute avoidance rule? I think we feel a kind of suspense as we're waiting for the response to come.
Sure.
Okay, now this result actually surprises me very much. The results are 79% said yes, and 21% said no. Actually, I was expecting that that the common understanding of dispute adjudication boards is just to render a decision. That's it, not to avoid disputes. What do you think, Dr. Tariq?
Yes, again, I share with you the same expectation. I would have expected the percentage to be vice versa, but however,
yeah,
we will see during this.
Okay.
But this is promising. We will get a good webinar today.
Yes, that's very interesting.
Yeah.
So we'll go now to the final question. Final in this stage, Tawan. Again, before this webinar, were you aware that the Dispute Adjudication Board, as part of its dispute avoidance role, may render a non-binding opinion? Yes or no? Of course, the key word here is non-binding opinion, so not a decision as normally discussed, and a decision that is final and or binding and final and binding or just binding. All of these, we're just talking about just the opinion part. Okay, so the results, the answers are 74% said yes. They are aware that Dispute Adjudication Board can render a non-binding opinion, and 26% said no. Thank you very much for your participation, and now we can move on with the slides. Now, what I want to do in these coming few slides is share with you, I mean, now that we've discussed this last question, is share with you the references from certain dispute board rules that are known. This reference for opinion, the non-binding opinion, how it existed from early on in several dispute board rules. And we can start with FIDIC. And of course, now we're talking, what's important for us, what we're emphasizing is the earlier versions of these dispute board rules. So for example, when we talk about the FIDIC contract, the dispute board appeared first in the 1999 edition. And so we're talking about the 1999, we're not talking about the 2017, which is a subsequent edition of the 99. We will address the ICC, for example. We'll talk about the first edition, not the last, just to see when how this opinion originated and when and how is it referenced. So in the 1999, in subclause 20.2, which is a fairly long clause, you have this 3-lined 2 sentences, this small paragraph there that actually talks about if at any time the parties so agree, they may jointly refer a matter to the DAB for it to give its opinion. So this is, neither party shall consult the DAB in any matter without the agreement of the other party. So this is the only reference in the FIDIC 1999 contract that talks about the matter of opinion. And one thing to mention here is that in the 1999 contract, the Red Book specifically, the DAB is a standing DAB, and that's why you would not have this. I believe, Dr. Tari, you can correct me if I'm wrong. In the silver and the yellow books, you would not have this clause in there.
Yes, exactly.
Now, if we move on to the ICC, the ICC issued its dispute board rules in 2004, and the first edition, and then here in Article 16, there's this it's called informal assistance with disagreements. And so what is this informal assistance with disagreements? How can this take place? There are several ways that this can take place. There can be separate meetings between the dispute board and any party, and there can be informal views, and this of course accords with our discussion on opinions given by the DB to the parties. And then there could be a written note from the DB to the parties. This is a way that they can assist. And also any other form of assistance which may help the parties resolve a disagreement. Now, the thing that we want to emphasize here is that note that this is in 2004. Note that this matter of the dispute board for opinion in the FIDIC contract was in there since 1999. Now, as I'm going through these references, I want you to think of your experiences and your perceptions of dispute boards and dispute adjudication boards, and how in the industry were these provisions made use of or not. So in your collective experience, since working in construction, did you come across provisions like these or implemented provisions like these? This is really the core, what's at the heart of this webinar. Now, the ICC Disputes Board rules also in 2004, we went through this slide, and in the DRBF manual, so the Dispute Resolution Board Foundation has a manual that the manual was, the first edition of it was in 2007, and then recently there was a new edition of this manual. I believe it's 2019. Now, in the 2007 version, there is a section 2.4, which is called advisory opinions. And in this section, it defines an advisory opinion as an informal method of advising the parties on resolving potential disputes before they escalate. Now, bear in mind, if we look at the timeline, we talked 99, 2004, 2007. We had all these provisions about using the dispute board as an entity that can help resolve disputes, using them for an informal assistance. So according to the DRBF, the advisory opinion is just an informal method to help advise the parties of any dispute before they escalate. So the whole interest is we don't want the disputes to escalate into disputes and those potential disputes. We want to avoid the disputes. So typically, this advisory opinion is used soon after a potential disagreement arises, because you don't want this potential disagreement to fester and to grow. And then it provides the DRBs, and the reason in the manual, in the 2007 manual, the reference to the dispute board is the DRB, the Dispute Review Board. In the recent manual, there isn't. It's a more general name. It's just a dispute board. So it provides the DRB's likely assessment of the party's merits. And I think this point actually is to me super critical, because imagine that the parties refer to the dispute board for an opinion, and the opinion comes in a certain, say, if it's for the contractor or for the employer, then what's going to happen is that the parties are going to think twice before they raise something to the dispute for a decision, because now they know where they're inclined, where they're heading. So I believe this actually can provide a trigger for an amicable settlement, for example. So this part is very very important, and the process for this opinion is very quick and maybe entirely oral. So there may be no written submissions at all. And in the DRBF manual, there is you can say like a proposed quick method, you know, that for this opinion to take place, this informal assistance to take place. And as we can see here in the slide, basically there's just brief documentation that is requested from both parties, just very brief. It's not a elaborate statements and you know elaborate documentation and attachments, just a brief documentation from both parties. And then there's an advisory meeting that is held where both parties do a presentation. The dispute board asks some questions and they get the answers, and there's a short intermission, short break, and the DRB or the dispute board internally discusses the opinion, and then finally the meeting is reconvened and the dispute board provides their opinion to the parties. Now, actually, I personally went through an experience like that, and it just takes maybe takes an hour or something. Now we come to the CR-CICA dispute board rules, and it's although of course the CR-CICA rules are in 2021, but it's of course we are having this webinar in the wake of the launching of these rules. And but if you look at the reference here to an opinion, it's actually, I think you'll find it interesting. So first of all, we have an Article 13, informal dispute avoidance. And this clause says that upon the joint request of the parties, the DB may informally assist the parties in the avoidance of disputes by providing an informal advisory opinion. So at this point in time, this really accords with what we have seen in the other forms of other rules, right? So here, the most important thing about an opinion is that it has to be it's something that the jointly requested by the parties. So one party cannot ask for an opinion. The both parties have to jointly ask for an opinion. And of course, the dispute board may informally assist the parties by providing this informal advisory opinion. So far, so good. But what's really interesting is the next part is that the dispute board may, on its own initiative, so even if the parties don't ask the dispute board for an opinion, the dispute board may, on its own initiative, raise any matters with the parties jointly in an effort to avoid any potential disputes and in an endeavor to help the parties. So here, the dispute board is really taking a very, very proactive role. So even if the parties do not ask for the dispute board's opinion, the dispute board steps in and they try to assist the parties. So what do you think would happen in this case? Of course, one of the first thing that might happen, which is very expected, that the dispute board may try to raise a matter with the parties, but then one of the parties might say, why are you being involved? We didn't ask you for an opinion. We don't want your initiative, right? This can happen. So that's why the second paragraph says that the parties may stop the dispute board's initiative, provided that they jointly notify the DB in writing that they regard DB's initiative unnecessary. So again, to stop this initiative, there has to be a joint agreement between the parties. Now, I think the tricky part here is, what if one party welcomes this opinion and the other party does not welcome this initiative? So what do you think, Dr. Tariq, in this kind of scenario?
It's clear that the dispute board will continue its initiative and render the non-binding opinion in such case. It can be understood from the wording.
Yeah. I think it's very, very probable that it could happen that you can have a party that would just disagree for the initiative and another party that would, agree. So now let's go to, now in this question, we would like to have your engagement. So now we'll just ask these questions, and then we want to hear your voices and your opinions on these. So in your opinion, why has this advisory role been overlooked in the MENA region? So what's the reason for this? So if you can raise your hands, and then we will pick on someone, and then you can share your thoughts, please. And you open your mic. So Bashmans Mohammed Haidar. Bashmans Mohammed, is your mic unmuted? So first we have Mans Mohammed and Bashmans Ibrahim. Okay, so the maybe can you, until we resolve this sound issue, can we? I think Bashmans Mohammed is unmuted now. Can you hear us, Bashmans Mohammed? Can you please share your thoughts, at least now, on the chat? So why do you think that this advisory opinion role has been overlooked in the region? Of course, this is if you agree that it has been overlooked in the region. So please share your thoughts through the chat for the time being. So Mr. Sean Gibbs says that the parties' relationships have broken down and have no faith that the other will respect a recommendation. Okay. Any other thoughts? Mr. Abu Aqar says that because of their culture of conflict. Can you elaborate on this? Mr. Osama mentions, Mr. Osama Montawi, I think it's overlooked because parties rely that commercial settlements at the end of the project would resolve everything. Maybe if we take that point, so what do you think about that, Dr. Tariq? Is that, from your experience, could that be a reason why this clause could be overlooked?
I may agree with most of these causes for such attitude towards the opinion. However, I would think of another cause which could be a historical one. The dispute boards under FIDIC, which is the most used conditions having this dispute board provision, actually replaces the engineer's decision provision under FIDIC 1987. So I could think of this as a reason that the parties may think that since DAB replaces the engineer's role of giving decisions on the disputes, so that's why they may thought or think that even the dispute board has this sole role as giving decisions. So this is maybe a historical reason.
Okay. Well, then Mr. Abu Aqar mentioned that if I can go back to his opinion, that the parties may think that an opinion is not helpful to resolve their disputes. Now, Mr. Abu Aqar, can I ask you to express your? Can you open the mic and share your thoughts?
I think Mr. Hussein is opening his mic. He can talk with us. He is raising his hand also.
Sorry, I didn't get that.
Hi, it's Sean Gibbs. You asked me to unmute.
Yes. Hi, Mr. Sean.
Yeah. Just sharing my experience, and I've worked across the MENA region, so that's in Libya, Egypt, UAE, Qatar, Kuwait, Oman, and Saudi. Obviously, one of the issues with the FIDIC forms of contract is that they're heavily amended, so the provisions for dispute boards are removed, and also for advisory opinions can be removed. But what I think quite often happens is that the parties start well-meaning to work together, and the relationship deteriorates. So by the time that somebody could actually refer something, neither's got confidence that the other's going to respect a recommendation, and they feel that they actually need a binding decision if they've got to that point quite often. As I touched on before, the standard forms are so heavily amended, usually in the MENA region. One of the reasons is obviously that a lot of the other countries that use the FIDIC forms of contract don't amend them as heavily because they're reliant on World Bank and other multilateral bank development funding, whereas quite often it's private funds that are used for the projects in the MENA region, particularly the GCC countries. So they don't need to keep the standard forms unamended.
That's a fair point, Mr. Gibbs. I actually, the question was actually intending to address not the matter of amending the contract, but even if the contract, say, if the parties have agreed to I know this is hard to imagine, but they agreed to an unamended FIDIC contract, for example, and the clause is intact. The question sort of implies that the parties in the MENA region would not be inclined anyway to ask the dispute board for opinion, despite the fact that, as we have presented, there were references for opinions since 1999, and then in 2004 and 2007. But we don't really in the region, we do not hear of a lot of cases where the dispute board opinion was sought, this non-binding recommendation was sought.
I've got to be honest, I think some of it's to do as well that you don't usually have standing boards. I've seen a lot of ad hoc boards used.
Yes.
But you don't have the benefit of the standing board. So it's really when the disputes crystallize that the ad hoc board is convened. I think if it's standing boards, I think people would use it more often. And would be willing to use it, and they've built up the relationship and the confidence in the dispute board members.
Yes, that's a fair point. Thank you, Mr. Abu Aqar. Abu Bakr, sorry, Abu Bakr.
My name is Abu Bakr.
Yes.
Yes, thank you. While I'm not from MENA region, I'm from West Africa. But I think we still can explain the position I've expressed by the fact that people in the region, in Africa in general, they're more inclined to a conflict. In the business, people tend to resolve issues by decision instead of an opinion. Except that there is a culture of mediation, but it's not as sought after as the DBA, the dispute board sort of mechanism. That's what I meant by it's a cultural issue. It's more than people instead of having resorting to a dispute board, they would rather fight and get a conflict or go to an arbitration or litigation, etc. I think it's a matter of education to educate people to more and more see the interest of resorting to dispute boards, which is which helps especially in long-term project like construction.
Dr. Sari, do you want to? I was just going to say that you bring a very, very interesting point, the matter of culture, and personally, I would have thought, at least speaking about the MENA region, I think the culture does not welcome really decisions because one of the parties would not be happy. So I would have thought that actually. When you have a non-binding opinion or a recommendation, that can be the first step to a amicable settlement, for example. So you would not need a decision. I think everyone would be happy because with an amicable settlement, it's a mutual agreement. So there's no one is forced to accept a certain decision. But the use of an opinion paves the way for that amicable settlement. So thank you for that. We can take one more contribution. So we have on the chat an opinion by Mr. Ayad Ali says that it could be regarded as a waste of time due to the non-binding nature, and actually it may prejudice the amicable resolution. Dr. Tariq, I know I'm speaking a lot, so maybe you can address this part.
This could be a reason. However, I personally do not agree with this approach by the parties, and I believe with time, when the parties use the dispute boards in their projects, and when they face these types of disputes in the projects, they will be well convinced that asking for non-binding opinions is much better than resorting to the dispute board for a decision, and it's never a waste of time. And maybe when we reach the part of the case study, this would be well presented in the case we will present to you. So yes, there could be some sort of thought for the parties that this is waste of time since it's not binding. However, I can assure you that this would would not be the correct way to deal with this non-binding opinion.
I just wanted to add something. Thank you, Dr. Tariq. When you say, Mr. Iyad, that it could be regarded as a waste of time, just the non-binding nature, the one thing to bear in mind, you're right, it's non-binding, but the goal that we'll be after is this binding contractual agreement, this mutual agreement with the parties. So that's the strongest thing. So actually, if we go with the decision, for example, and a party is not satisfied with the decision, then the next step would be, of course, amicable settlement for the predicate contract. Then you go to arbitration, and then arbitration tribunal will look into the dispute board decision and so on and so forth. But when you have a mutually agreed, or you have an agreement that is signed by both parties, and this agreement is actually triggered by this opinion. So this now, the parties have read the opinion, and then they talk together, and then they come up with this agreement, this mutual agreement. So that's when. So it's not just to comment on your statement. It's not that the recommendation, the opinion is non-binding, but it can lead to this agreement. And this agreement is really what we're after. Now, Mr. Iyad, if you can you open your mic? Because I had a question for you, actually. You said it may prejudice the amicable resolution. I just wanted to understand what you mean by that it may prejudice the amicable resolution. Now, can you open the mic and share your views on how it can prejudice the amicable resolution? Okay, maybe we are having difficulties with that, but if you can just pitch in with your opinion on that, that would be great. Now, thank you so much for your contributions. We'll just go for the sake of time into the next slide. It's another question, which is, in your opinion, how can the construction industry benefit from this advisory role? So maybe we've shared some thoughts with you, but do you even believe that the industry can benefit from this role or not? And how can the construction industry benefit from this advisory role? If you can contribute on the chat, that would be great. Or if you can raise your hand, and so we can, and then you can contribute orally. Okay, I see that Mr. Gibbs also has his hand raised. And so, and also, yeah, go ahead.
Hi, it's Sean Gibbs again.
Yeah.
I think the industry needs educating, so people are aware of how they can use the dispute board opinion process. And I think it comes back to as well having standing boards where the parties build a relationship with the dispute board members and have confidence in them and are willing to listen to them when they offer advice or opinion. And I think it's very much a matter of education. There's a lot of people that are administering and working with the fitted contracts that don't necessarily understand them and use them fully. And I think this is an ongoing process. Obviously, the DAB, the DAAB, only came out in 2017. There's very few contracts that are actually using the 2017 form. People are just starting to tender with them in the last sort of 12 months. We're starting to see projects that are likely to go ahead under them. And I think it's very much an education and an engagement within the industry to learn about this and how they can best use it. Yes,
I think it's very interesting also that you always you're always mentioning the element of trust and the standing DAB, and I think that's very, very important, and it's something that maybe I think is lacking, as actually Mr. Abu Bakr mentioned. There's a cultural factor, so I think culturally probably there's lacking this element of trust, but yes, I think the role of the standing DAB and the trust can play a big role in advancing this advisory role of the DAB. Also, we can take a, I think Ms. Noha Hassan says that I think only the binding contract may force the parties to go use the option of advisory role before raising or escalating any dispute. That's an interesting point. So I think what you're saying, Ms. Noha, is instead of saying in the contract the parties may use the DAB for opinion, the contract would say that before going to arbitration, for example, the parties shall use the opinion of the DAB, for example. I think that's an interesting point. So the parties will have to have this in their contract, this advisory role. If we take another also random contribution. Any opinion, recommendation, or decision by a respect. This is from, excuse me, for the wording, the clause. If I'm sorry if I mispronounced your name, clause. It says any opinion, recommendation, or decision by a respected neutral can open the eyes of the parties and make them rethink their initial position. Absolutely, I fully agree with you. And also I would add to your statement is that when it's an opinion recommendation, if you break your statement into several parts, you have opinion, recommendation, or decision. Let's put the opinion recommendation on one side and a decision on one side. So if we say opinion recommendation, yeah, I definitely think it can open the eyes of the parties and make them reconsider whether they want to even go to the decision or not. But once you have a decision, then it has to be implemented because it's binding. So then that's a different story. But I fully agree with you. Do you have any comments, Dr. Tariq?
Fully agree with this, and maybe this is the main factor of the success of any dispute board, that the members have the knowledge and experience to put them in a position that both parties respect their opinions and their decisions. And this, of course, is largely based on the knowledge, experience, repetition of the members. Yes.
Yes. Also, there's a comment there that even if you have a decision, they can still turn to arbitration. But remember that we are trying to avoid going to arbitration, and even trying to, through this advisory role, trying to avoid the dispute altogether. So this is really the whole issue. We do not want even a contractual dispute to arise. So when you have an opinion from experts who are, the dispute board panel, and this opinion, as I said, leads to a binding contract agreement or a settlement agreement, then everybody's a winner, because if you settle disputes, it's not going to arbitration. You don't even need a dispute board decision. Of course, it can be also mentioned once you have a decision and before going into arbitration, this would also can prompt a mutual agreement. Okay, thank you so much for your contributions. We'll go to the next slide now. basically, I was doing all the talking so far, and I apologize if I bored you to death. But really, I was really actually saving the best for last, because now in this remaining part of the presentation, we'll have a Dr. Tariq share with us his experience, a case study where the dispute board was used for opinion, just the opinion. So we'll listen to Dr. Tariq, and then we'll take it from there.
Thank you, Dr. Walid. I would like to start with my personal opinion on the role of a dispute board for dispute avoidance. I personally believe that the main role of the dispute boards is not rendering decisions on disputes. Rather, the main role of any tab is to avoid the disputes, to prevent disputes from escalation. And this brings the importance of the role of giving non-binding opinions to help the parties to avoid the disputes. So this is the first point I wanted to start with. And of course, the success of the dispute board process in general is much dependent on the performance of the dispute board members, on their knowledge, experience, and fair determination and opinions given to the parties. Going to the case study, this is a project, just to give you an overview of the project. This is a road project in a mountain area in a European country. This project included 2 tunnels and 7 bridges, in addition to some slide protection works. It was a project financed by a development bank. So normally or typically it was a FEDEC MDB harmonized edition with a standing DAP consisting of 3 members. The project started since early 2018. Till date, there are 10 site visits. 7 of them were physical site visits, and due to the COVID issue, we held 3 online site visits. The project is now approaching completion, successful completion. No decisions neither party has requested for a decision from the dispute board, and there were 3 required or requested opinions. And I'll present here 2 of these 3 opinions. And by the way, the opinions rendered by the dispute board on the 3 cases were all reached by unanimity between the members, and neither party has requested a decision in respect of any of these opinions, either by the contractor or the employer, or both parties accepted or did not challenge any of these opinions. So we go to the first requested opinion. It was related to the engineer's determination. And by the way, this requested opinion was requested orally on one of the site visits during the meeting. And as Dr. Reed has just said, the members of the dispute board asked for maybe 30 minutes or something to discuss and rendered the non-binding opinion on the issue. The question which was raised jointly by the parties during the meeting says that is it permissible for the engineer to modify his determination after having issued it to the parties? This was the question. And the background of this question, there was a variation. The engineer made his determination and set a price for this variation. And later on, after the contractor submitted further details, particulars, and challenged this price, the engineer changed his mind and made another determination with another price. So this is the background of the decision, and this is of the question, and this is the question. And of course, the dispute board opinion read that in the dispute board opinion, there are no contractual barriers which would prohibit the engineer from issuing a second determination in the situation described in the question. And in fact, this is a perfectly normal situation. Both parties were satisfied with this opinion. Both the engineer, both the employer and the contractor accepted this opinion, and no further conflicts or disputes were raised in this regard. What I want also to highlight regarding the opinions is that normally the dispute board, when it gives its opinion on such a question, they need to confirm to the parties that this opinion is non-binding. Either party may raise the issue to the dispute board to ask for a decision, and neither party is limited in his submission with regard to such request for a decision for the documents or arguments submitted for the non-binding opinion. And of course, the dispute board is not required or obliged to follow the non-binding opinion if later on, under the process of rendering the decision, it finds out that it has to change their mind regarding the issue. The second dispute board opinion, actually, it consists of three sub-questions, and it relates actually to the certification and payment issue, which I believe is a common source of conflicts and disputes in our region. The first of these three items of the question is, what is the effect of an interim payment certificate with regard to the employer's obligation to pay the amount certified? Second, what are the consequences if the employer fails to pay an amount certified by the engineer? And third, is a deviation between estimated quantities in the bill of quantity and the executed quantities exceeding 125% a variation requiring formal approval of the employer via variation order or contract amendment? These are the three questions. And the background for these questions is actually, as you may have thought, is that the actual executed quantities exceeded 25% of the estimated quantities. The engineer certified the actually executed quantities. The employer was reluctant to pay such amount exceeding 25%, and even delayed payment until, according to his understanding, these certificates are corrected by the engineer. So this is the background for these three questions. And
If I may,
please,
is
sure.
in the project, is that a FIDIC contract or some?
Yes, it's FIDIC harmonized edition. Yes,
yes.
yeah, because it's financed by a loan by the development bank. So to answer the first question, the opinion of the dispute board was clear, based on subclause 14.6. There are no provisions in the conditions which allow the employer to unilaterally adjust the engineer's IBC in case of disagreement over the amount determined by the engineer. So this is, which means and follows that actually the employer is therefore under a contractual duty to pay the amount determined by the engineer in any given IBC. So coming to the second question, what are the consequences if the employer fails to make payment for such certified amounts? And of course, the opinion of the dispute board was based on the contractor's entitlement under subclauses 14.8, delayed payment, 16.1, contractor's entitlement to suspend work, and subclause 16.2, termination by the contractor. And the opinion of the dispute board is that the contractor would be entitled to apply any or to exercise any of his or all of his entitlements under these clauses. For the third item of the question regarding how to deal with the quantities exceeding 25% of the estimated quantities, the dispute board referred to subclause 14.1, which defines the status of the contractual quantities in the bill of quantity, which are just estimated quantities, and the contract price will be calculated based on the actual quantities. And then the dispute board referred to the fact that the duty of the engineer is to certify the net actual quantity of each item according to subclause 12.2. And finally, the dispute board concluded that the dispute board does not consider the execution of actual quantities if exceeds 25%, that this would amount to a variation in itself, and that the engineer can simply certify the actually executed quantities without necessarily or without a requirement under the contract to issue a variation with regard to these additional quantities. So these are this is a case of actual opinions that were requested from the dispute board. And these are the dispute board opinions, which, as I just highlighted, were accepted by both parties, the contractor and the engineer. And as I expect, this actually prevented any escalation of this issue or this matter to further steps, either for asking a decision or for arbitration. Thank you, Dr.
Thank you, Dr. Tariq. So you're saying that in this case, all of these opinions were followed and the parties did not request a decision for the dispute board?
Exactly. They were followed. And by the way, as I also highlighted,
that's great, Dr. Tariq. This is actually, maybe this goes at the heart of the webinar tonight, is that this is just an example of how, you can imagine all these questions that Dr. Tariq mentioned. They could have very well, each one of them, been you've gone through a lengthy process of referrals and responses, statement of case and a response to that, and then a hearing and then a decision, and someone would not be happy with the decision. But then when you just have an opinion and the process takes a few minutes, so you can imagine how that saved time and effort and money, and so this is really the essence of what we're trying to drive at in this webinar, is using the dispute boards for opinions and for dispute avoidance. We don't need to even resort, although they're called dispute adjudication boards, but the fact that they're adjudication boards does not mean that we cannot use them for opinion. And actually, now with the AAB part, we can really emphasize the avoidance part. And this adjudication, rendering a binding decision, can just happen when the amicable solutions have failed, or the opinions, the parties decide to go notwithstanding the opinion with a decision anyway. I mentioned during my part of the presentation that I came across also a matter of opinion with dispute boards, and as Dr. Tariq actually mentioned, it just took, this one was actually in written form, and it just took maybe less than a day, and it was resolved, and it was a very heated debate. And I'll explain it because I'm sure a lot of us we go through this heated item. This is more of a cost issue, as we know in most contracts. There's what is called the general requirements, and these are the first division of the specifications. They're called, I think the American term is general requirements, the European term is preliminaries. So you have these general requirements, and the contractor gets paid a sum of money that is in the bill of quantities for these general requirements, and it covers just general expenses, quality control, scheduling, cleaning towards the end of the project, so and facilities, so on and so forth. So what happens when the contractual time for completion passes and the project is continuing and the general requirements have been paid? So in the contract, so we have in that project that I'm mentioning, the engineer decided to say, for example, if it's a lump sum amount, the general requirement the general requirements for the project. And so the engineers decided to stretch whatever amount is remaining throughout the actual duration of the project. Okay, so if there's a forecast 3 months left, then they just distribute that the remaining part onto the 3 months. Of course, so that means that the contractor would really be taking a lesser and lesser amount. And of course, a dispute arose between the engineer and the contractor, and that this is the contractor. What the contractor wanted was continuing on the lump sum. You can say a fixed monthly amount to cover the contractor's expenses, and the engineer said, no, this is a lump sum amount, and this will be stretched throughout the actual duration of the project. And this is a heated issue, and I know that I think it was raised in an arbitration case here at CRCCA at some point. But in the project, this was actually the only we had in that project, maybe something like 15 referrals and for decisions, and only one opinion. And this is really was the only opinion, and the dispute board rendered an opinion that basically that the contractor should be given the this monthly expenses, monthly amount, and that by the end of the project we would see who's the cause of the delay, and then this would be set off against the payments made to the contractor, and that opinion was followed straight away. So there was no need to go to a decision or this was not added to the list of disputes in the project. So that's another example of how opinions can work. And I like to think of this issue of opinion and avoidance as I'm actually a very strong supporter of also mediation. And I think in mediation, both parties are winners because they reached their decision, their mutual agreement by themselves through a medium, which is the mediator. So along the same vein, the dispute board here tries to help the parties through their opinion. That's a step for them to help them reach a solution that they both agree to. So that's really these are really our thoughts, and at this point, really we've come to the conclusion of our point. Now we'd like our presentations. We'd like to open the floor for your contributions and your questions. So first, I will just take the look at the Q&A, and we have a question that opinion to be understood differently from recommendation. That's the question. The opinion here is equivalent to a recommendation. Of course, unless Dr. Tariq, you have a different point of view.
It's equivalent in its let's say the significance of the opinion or recommendation. However, I may understand this question maybe it's referring to the dispute review board and the recommendation rendered by the dispute review board. Maybe the procedure is different. However, the end result, I believe, is the same.
Okay. I understood it. Opinion is versus not the dispute boards, but maybe we can have a dispute board provide an opinion on this dispute. Sure. But there's a question: where can we get the record of this webinar? I believe there would be a link after the webinar with a link to the recording. It will be posted, I believe, on CRCCA and several. How would the DB know about the disagreement before taking the initiative to call the parties jointly? That's an interesting question, and that goes to the point that Mr. Gibbs was making about having a standing DAB and having their presence on site. So as I mentioned, the standing DAB, they come to the site regularly, even when there's no disputes, and then they get a feel of what's going on. The contractor presents like the progress and the employer comments or has his own presentation, and the dispute board goes to the site and they look at the site, and then they're discussing with the parties. And of course, as the progress report is done, issues arise. You can see that, okay, these are signs where this is going to be a potential disagreement, it's a potential dispute. Would you like help with this problem, this issue? And this is how the dispute board would definitely know that there are issues and how they might take an initiative to try to resolve the disputes. I was actually in a project in North Africa, not in Egypt, and actually, interestingly, the parties had actually, to my surprise, had jointly agreed at some point in the project to not make use of the dispute board for anything, for opinion or for recommendation, which is actually this is a unique experience in itself. But this is really how. And I actually had another experience here in Egypt where, like I said, for some reason there's a resistance to use the dispute board for opinion, and the dispute board, one of the dispute board members, a very prominent gentleman here in Egypt, was telling that, it was trying to bring this point home to the parties. We're here to help you. We're here to provide. We can provide an opinion. Just make use of us. But then again, maybe, and this is one of the reasons we're having this webinar. It was just not made use of this issue, this factor of opinion. Mr.
And also, again, just support what Dr. Reid has just said. In addition to the site visits, normally the dispute board receives a folder of all the communication and correspondence between the parties during the period for each site visit. Beforehand, before he visits the sites, each member would have a package of all the correspondence during the period. So this, again, in addition, of course, to the site visits and the visual inspection and so on.
Mr. Robert Henry mentions that the NY 58 and UN Central, there is no mention of these two powerful entities. You're right, but all we were doing here is just providing random examples of the use of opinion. It's not a full list of where the opinions can be used, and the whole point was and this is the point that we'd like you to think about as you leave the webinar, is this matter of opinion was mentioned since 1999 in writing in standard forms of contract, in well-known institutions, and yet at least from my experience, this very valuable tool was not made use of. So we have, in the States, dispute review boards are very popular, and in the Middle East, dispute adjudication boards were very popular. But the whole notion of dispute adjudication boards is always about the decision, about the binding decision, and about, if you look at all the topics that are discussed, is does the dispute board are there decisions enforceable, for example, in the Middle East or not? So it's all about decisions, and this dispute avoidance role or the opinion part is not really made that much use of. We have a question from Mr. Shahib about can we propose the model of UN Central Singapore Convention or mediation treaty that has taken into force, which most countries have ratified and signed, to be used so that the parties would initiate mediation as an alternative dispute resolution. And now, that's a loaded question, and actually that would deserve a webinar on its own merit, and not because that touches on mediation as an alternative dispute resolution method. And actually, so because this webinar is purely focused on the dispute adjudication board's opinion. So that's why we would defer the answer to that, because mediation, of course, as I mentioned, is I believe a very valuable tool. And actually, I think I see a lot of parallels between mediation and the role of avoidance in some respects. Now, can we have your, if you want to raise your hand, and then we just have a live discussion. So maybe we can see if there's any raised hands, and then try to. We can take any question now. If you can just participate by raising your hand and asking the question orally. Would love to hear your voice. Okay, Mr. Alfonso.
Yes, thank you. This is Alfonso from Italy. You mentioned mediation. I wonder if when delivering an opinion, can or should the dispute board assume the role of the mediator, that is proposing a balanced solution which half satisfies both parties but would avoid the dispute, instead that the role of the adjudicator, which is the role of the dispute adjudication board, and which who will act according to the contract and likely will dissatisfy one of the party or even both?
I think that's a very interesting question. Dr. Tariq, you want to answer that one?
I believe that mediation by definition means that actually there is a dispute. However, in the opinion, dispute does not exist yet. So actually the opinion or the decision, both are given based on the contract and the facts. So I'm not sure if the role of the dispute board in rendering opinion, non-binding opinion, they take the role of a mediator. So I'm not quite sure that this is the right or proper description of the role to render non-binding opinion. And Dr. Reid also can.
Yeah, well, actually, Mr. Alfonso, I actually, something popped in my head, and it had to do with the FIDIC contract. So, you know, the chronology of the clauses is that you have the dispute board, say, for example, opinion / decision, but then after that, there's the amicable settlement, and then there's arbitration. So, maybe if the parties, and of course, I mean, this is just a thought, if the parties had written in the contract that the dispute board will render a, like in the FIDIC contract, they can be used for an opinion, but then they will render a decision. And then once you're out of that stage of the decision, then that triggers, I think it's clause 20.5. 20.5 talks about amicable settlement. It does not specifically mention mediation, although in one of the FIDIC guides, you know, the FIDIC guidelines, that they mention that mediation, I think it's in 2017, they mention in the guideline notes that mediation is one of those amicable settlement methods that can be used. So maybe if the parties had mentioned in the contract specifically that one of the dispute board members will take on the role of mediator. Say if one of the dispute board members is a very well-known mediator, for example, then I think that could play into your question. I would think if there's a contractual reference to a mediator who happens to be one of the dispute board members who would take that amicable settlement role. So this is, as Dr. Tariq mentioned, the dispute board, and he's absolutely correct. So there's a dispute that has to have arisen for the dispute board to render a decision, and of course, the opinion that there is no dispute yet. But once you're done with the clause of rendering a decision or an opinion, and you go into the amicable settlement clause before going into the arbitration, then if the parties had requested that the dispute board, one of the members becomes a mediator, maybe that would work. Actually, I want to share something that was interesting. I was in a conference in Turkey in 2016, and a question from one of the question was asked to the panelists: can the dispute board members become arbitrators? So can they? So when you go to arbitration, for example, can the arbitration tribunal become? Can they be the dispute board members? And I think that same question was actually raised in my, in this dispute board experience that I was sharing with you. Actually, one of the contractor actually raised this issue for the employer for consideration in front of the dispute board. Is can these same people, these same members, become the arbitration tribunal? So that was I think that's an interesting thing that also plays into your question about mediation. I see Mr. Iyad says no, they can't. Yeah, of course that's understandable, but it was an interesting question actually to ask. I would think. Do you have any comments on that? So any other question? Any Mr. Muhammad Quraim?
Good evening, sir. Do you hear me?
Yes, we can hear you, yes.
Good. My query, should all parties, contractor, employer, engineer, CC their correspondence, minutes of meeting, variation order, reports, whatever, so to dispute board, or not necessary?
No, it's not common to CC the board members in all correspondence. However, what actually happens is that, as I said before, each site visit, the parties, the contractor and the employer, provide the dispute board with a joint report for the status of the project during the period between the two visits. But no, to answer you in short, no, it's not common to CC the dispute members in all the correspondence. But at the end of the day, it has the same effect when the jointly report status report is submitted to the board.
Okay,
thank you.
Thank you.
Thank you. Just a few questions from the that were posted in writing. Mr. Wagih Hisham says, sorry, but can you explain the differences between a DAB and a DAAB? So if I may, I'll just pitch in that one. The DAB is just a dispute adjudication board. Its primary role is to decide or adjudicate on disputes. And as we've mentioned, as you've seen in the slide about the FIDIC contract, there was this just very small paragraph that talks about that they may be used for opinion, but so their primary role is to decide on disputes. However, a DAAB has two A's in there. There's the adjudication role, which is we just mentioned, but there's also the avoidance role. So the role is not just to decide on disputes, they need to avoid disputes. And to avoid disputes, there has to be a proactive role of trying to really avoid that, as Dr. Tariq mentioned, we don't want the dispute to even be there in the first place. That's why, as you can see in the CRCCA rules, that really comes into play when the dispute board is the one that it can even initiate trying to, even if the parties do not want to, they didn't ask for an opinion, they didn't ask for a recommendation, the dispute board in its own initiative can actually try to do that just for the sole purpose of avoiding disputes, and that's why you have the DAAB, this A part. Mr. Iyad is asking an interesting question. Can the DAB opinion be sought either before or after the engineer's determination? In my personal opinion, it can be sought either times, before or after, because in all cases, the opinion really, the sole purpose of the opinion is just trying to avoid the dispute. So if it's sought before the determination, then maybe that opinion may influence the engineer's determination in any way. If it's sought after the determination, then maybe that's going to affect the parties' willingness to, because after the determination, remember the step is the dispute board decision for the DAB part. So and as we mentioned from the DRBF manual, when you have when you know that you have an idea of what the DAB's opinion is on something, then the parties will think twice before going for a referral. So that's, I think, how it comes into play in both. Dr. Tara, do you have something you want to add on this particular point?
No, I totally agree with you. This is the and in both cases, this would help the parties avoid disputes.
We just have maybe just a few minutes, just room for one more question. If anyone wants to, we can make it a live question if you raise your hand and we answer the question. I think Mr. Ahmed Ibrahim.
Hello?
Yes. I can hear you, Mr. Ahmed.
Okay. This is Ahmed Ibrahim speaking from Canada. Actually, as far as I understand from your talking, that the DB can be assigned on the project from the beginning, from the early beginning of the project, and they can receive all the correspondences. Actually, this is a brilliant idea, but I'm wondering if you have experience with such thing, because I didn't experience anything like this before. And if there is like a possibility to do that, what will be the arrangement in the contract? Who will be those guys, and the arrangement in the contract will go? And if these guys are on board, their decision will be binding to the contractor or to the client in any dispute will be arise between them. It is a brilliant idea. It will solve a lot of things. And also my question is, if these people are there, what will be the role of the contracts manager for the contractor? Because this guy should be responding to letters, making claims, negotiating about disputes like this. So in the presence of this DB, what will be his role? He will be just doing the procurement, or I'm not sure. Thank you.
Want to answer?
Yes, there are a lot of questions here. Yes, if there is a dispute board, standing dispute board from the beginning of the project, of course, the contract has to have some provisions for this dispute board for the procedure, for the duties, and for the site visits, and for all issues that are required to deal with this dispute board. And also, maybe you are referring in your written question regarding the payment, how the dispute board would be paid. Actually, he is paid by both parties, the employer and the contractor. However, normally the process is that the contractor pays to the dispute boards and then apply for half of such amount in his statements submitted to the employer. So these are the questions I put. You have.
Well, there are a lot of stuff that is done.
Yeah, I just want to say that the answer to your question, really, you're saying this is an excellent idea, but the FIDIC contract, the 1999 Red Book, has the complete answer to your question. So this, the dispute board in the FIDIC contract, starting from, I think it's clause 20.3, onward until 20.3, 20.4. That's called a standing dispute board, which, as we mentioned, standing dispute board is there from day one or maybe day 30, if we're and it's there so that it's like with the parties throughout the duration of the contract, trying to it's like with them, they're trying to resolve disputes as they arise, and once a dispute arises, they want to issue a decision. If an opinion is not requested, then that decision, so that the parties can just get on with their lives and with the project, and the dispute is decided upon, not continued forever. The part of your other question about the mechanism, you'll find in the FIDIC contract, at the end of the FIDIC contract, there's something called the procedural rules. And in there, and there's also a form of agreement that would be signed with the dispute board members. It has all the mechanisms that we mentioned. To be specific, the standing dispute board, they would be paid what's called a monthly retainer fee. So each month they would be paid a fixed amount, each member, and they would also be paid on top of that an amount for when they come for site visits, for example, the hours that they spend, and on top of that they would be paid for the when they are working on a decision, for example, or an opinion. So you have like 3 layers. Of course, in the ad hoc case, if you have an ad hoc dispute board, then they don't get paid the monthly thing, because they're not there for that duration, but they will be paid for providing their decisions on the dispute, the time that they spend looking at the dispute. One point that I wanted to mention also, actually I forgot it. So, but you mentioned your last question was about the issue of this the contract manager from the contractor. What would he be doing if these guys are on the site? He'd be doing exactly what he's doing. So actually his work would be maybe he'd be a bit busier, because like we mentioned, if the dispute board is being sought for an opinion, so this contract manager would probably help draft this, for example, first of all, raise the issues that need an opinion, and jointly with for example, if we're talking about a contractor, jointly with the contract manager of the engineer, they have to jointly make a question for the dispute board to provide an opinion on. And this is, of course, if it's written. Now, suppose that we're not going for an opinion and they're going for a decision. This is a bit of a lengthy process, because this contract manager would have to prepare, of course, in coordination with the team, they would have to prepare a whole statement of case, if the one we're talking about the contractor, the first part of the dispute board, say procedures for rendering a decision is first, they first establish how called this procedural rules, where the procedures to be followed until a decision is made. And that procedure usually consists of written submissions between the parties, and you can imagine the contracts manager or the contracts team, and actually the project team, would really be involved heavily in preparing, say if it's a contractor, preparing these statements, and then the engineers team would be involved heavily in responding to these statements. So normally you can have one cycle or two cycles. So the contractor would submit a statement, and then this is like a report, and then the engineer would respond with one, and then there could be another reply and another reply, and then there's a hearing, and then before the dispute board provides its decision within 84-day period. And in my case, in this experience that I had, it was so, because I'm on the engineers team, and we had this dispute board procedure in one of our high profile projects that really lasted the entire year. And what happened, it was a major distraction from the normal workflow on site, to the point that we had to hire someone especially for the dispute board procedures. So you have the contract manager on site, but then you have also we hired someone specially for dispute board procedures to write submissions, to help assist with writing submissions. So it's a very heavy loaded process. With that, I just want to thank you all very much. I'd like to thank my dear colleague, Dr. Tariq Hamid, for his wonderful contribution and the wonderful case study. And I hope that this was of use. And thank you so much for your attendance and for your participation.
Thank you.
Thank you very much.
Thank you, everyone.